Hello viewers, this is Major General Neelendra Kumar for the YouTube channel Lex Consilium Foundation, and in conversation here with Mr. Raju Ramachandran, who's a senior advocate of the Supreme Court, has been a former uh, additional Solicitor General. He had been amicus for the Supreme Court in two well-known cases relating to Gujarat riots, and then in the appeal of Ajmal Kasab, and he had the distinction of having been designated a senior by the Supreme Court at the age of 42, was elected Vice President of Supreme Court Bar Session, and was also a consul for Justice Sawant Committee, apart from many other functions, appointments, and works of eminence that he has done. We are discussing here today the matter of presidential reference. You would recall the 20th November judgment. If I can call it, it is more appropriate an opinion, not a judgment of the Supreme Court, of a five judges bench headed by the then Chief Justice B.R. Gawai, with sitting with him Justice Suryakant, present Chief Justice, Justice Vikramnath, P.S. Narasimha, and A.S. Chandurkar. And the matter was the presidential reference made by President Draupadi Murmu. That was in the month of May, and this related to an April 25 judgment by the two judges bench of the Supreme Court that had Justices J.B. Pardiwala and R. Mahadevan. The matter pertained to the timeline within which the governor of a state must deal with, give his assent, or otherwise exercise the options available to him under the Constitution in relation to a bill sent to him for consideration by the state legislature. Justice Padiwala's decision is of April, so I will not dwell over it. What the five judges bench in presidential reference has said in nutshell is that no timeline can be fixed for the president or for the governor in the matter of assent or consideration of bills. So there can be absolutely no timeline. However, they kept a window open by saying that inaction can be taken if it appears that the governor has been having that bill for his consideration for a period that is prolonged, unexplained, or indefinite. In its advisory, the Supreme Court did not clarify as to what would constitute this unexplained, prolonged, or indefinite. And the jurists all over have expressed their views insofar as that one particular, in one view, it has been pointed out that this decision in the days ahead would be compared and would sit at par with ADM Jabalpur. Now, that's quite an extraordinary view. Now, my question to Mr. Ramachandran is that how do you see this judgment or this advisory?
Thank you, General, first of all, for inviting me to your podcast. It's nice to be speaking to you and your viewers. Now, this comparison with ADM Jabalpur is a bit extreme. I think it was Harish Khare who mentioned this in his column, The Wire.
Yes.
In the ADM Jabalpur case, the Supreme Court went on a textual interpretation of Article 21, and so he drew a comparison with that, saying here also the Supreme Court has gone textually, but there have been many other cases of textual interpretation. So this is not the ADM Jabalpur moment of the court, definitely, but this is definitely a very extraordinary opinion rendered in extraordinary circumstances. But the problem, according to me, starts with the original April judgment of Justice Pardiwala. There, the court was dealing with the specific Tamil Nadu situation, where the facts were indeed shocking. They were dealing with what I would call a rogue governor, whether you agree with my strong language or not. It was an extreme situation. So the decision was given by the two-judge bench with their hearts and minds in the right places, but they went wrong in two or three aspects. And if only they had shown some wisdom and sagacity at that time, this reference wouldn't have arisen. Let me explain why. That case raised an important question of law relating to the interpretation of the Constitution, which was arising for the first time. The judges themselves, the two judges, ought to have gone by Article 145 of the Constitution and placed the matter before the Chief Justice for being heard by a larger bench. Not doing so was the first mistake. If this case had been rendered, decided by a larger bench, the decision would have been more authoritative. Now, this is a judgment by a two-judge bench. Of course, the Supreme Court gives hundreds of judgments in two-judge benches and three-judge benches. But a matter of such constitutional significance, a decision by a two-judge bench lacks an authoritative stamp. Now, two areas where the court went wrong in that judgment, though in principle they were right, namely that the governor could not sit indefinitely on bills. There they were right. But to prescribe specific timelines was inadvisable, considering the fact that in other constitutional situations, including judicial appointments, for instance, collegium is a creation of the Supreme Court. Has the Supreme Court prescribed timelines there for the centre to act, except to say expeditiously? Has the Supreme Court ever issued a mandamus to make judicial appointments after collegium's reconsideration? It hasn't. So to enforce timelines, to prescribe timelines which can't be enforced was wrong. The highest the court could have done was to say it had to be done within a reasonable time. The second big mistake which the two-judge bench did was to suggest that the president should seek the court's advisory opinion when a matter is referred to the president for the president's assent. Now, this was clearly out of line. The Supreme Court itself has said in many cases that it is not bound to answer references. So imagine a situation where you are telling the president, please refer, and then the court declines the reference. There was no need at all for the Supreme Court to say that in a two-judge bench decision. But the point is that this gave a handle to the executive to, within a week of the judgment, seek this extraordinary reference. This was, in essence, an appeal over a two-judge bench decision. The court, in my view, wrongly entertained the reference because 11 or 12 out of those 14 questions were clearly and squarely answered by the two-judge bench decision. And if it was entertaining a reference on those very questions, it was really entertaining an appeal, which in a previous case, in the matter of Kaveri waters, the court had said it can't be done. You can't seek to set aside the judgment, but that is precisely what has happened in the present case.
Mr. Raju Ramachandran, if I may intervene here and put a question to you. You have yourself used the word, you started that it was an extraordinary situation. You also said and referred to a rogue governor. Now, I will put it to you that in this extraordinary situation, agreeing with you that the governor sitting on bills was not an isolated incident. And where it is said, when the Constitution, it is said that the governor, one of the options is gives his assent or withholds his assent. It is expected that this action would be taken within a reasonable time.
Yes.
If it is so, then would it be said that this phrase, reasonable time, would depend upon the whims and fancies of different governors? And the Constitution is helpless in such a situation?
I'm glad you asked me that question. It will help me to clarify what I intended to say. It can't depend on the whims and fancies of individual governors, but what is a reasonable time will always depend upon the facts and circumstances of a particular case. And therefore, faced with this situation, what the court could have done was to keep the matter pending and ask the governor to take a decision within a particular time. You know that courts do adjourn cases from time to time to enable an authority to take a decision to report back. They could have said, we'll call this case after 8 weeks, we'll call it after 3 months. Let the governor take a decision in the meantime. Let us know. That would not have amounted to the prescription of a timeline in the way in which it is done now, which looks like a bit of a constitutional overreach and also an impracticality.
Now, you said you view it as overreach and impractical.
Yes.
Rather than overreach and impractical, do you think that it would have been an impropriety because it is not impractical?
Well, impropriety in a constitutional sense, yes, because if one organ of the state transgresses its role, then it is definitely a constitutional impropriety.
Okay, right. Kindly continue.
Yes. So, having made my comment on the manner in which the reference was entertained, where I've already said it ought not to have been entertained, but having entertained it, and now that we have got this opinion, even if in the course of the next few minutes I refer to it as a judgment, that's only loosely. We all understand as lawyers that this is an opinion. Let us look at the merits of the opinion now that it has come. It is not entirely good, it is not entirely bad. One of those legal programs where I am not able to express an unequivocal view or a black and white view. It's good in parts, it's bad in parts. I see some constitutional wisdom in the conservatism which the court has shown as far as the assent by the governor is concerned. I think the point made by the court that the process of giving assent is a continuation of the legislative process.
Yes.
And therefore, the extent of the court's intervention in a legislative process has to be limited. I think there is great constitutional wisdom in that restraint. At the same time, the court has not entirely abdicated its powers because it says that in given cases we retain the power to ask the governor to exercise his powers within a reasonable time. In saying so, the court has expanded its own powers because it has indicated that it still retains the upper hand. It will lay down the law on a case to case basis. It wants the states to come to it. On the one hand, the black and white 3 month deadline of the Pardiwala bench is no longer good law. What is the timeline? What is reasonable? What is unreasonable will now be decided on a court to court basis, on a case to case basis. And so we are going to see a lot of litigation in the days ahead by non NDA governments. My fear is that R.N. Ravi will find many cousins and soul brothers among the other governors, encouraged, of course, by the bosses at the center. You will find more recalcitrant governors. You will find, therefore, more opposition ruled states having to come to the court against different instances of recalcitrance by the governors. So, to repeat, you're going to see more recalcitrant governors emboldened by this judgment, and you're going to see a lot of state versus center litigation in the months and years to come.
Now, this brings me straight to the question that do you think that this prophecy, if I can use the word by you, uh, is in tune with the constitutional intent and aspirations of the framers?
General, now you've asked me a question to which the answer can be very, very long, but you have limited time.
Right.
But I am not an original intent wala, right? Because that freezes the constitution. Here is a constituent assembly, not directly elected, though the recent book by Rohit and Ornit Shani brings out the element of popular participation.
Yes.
I would commend this book to your viewers, informed the deliberations of the Constituent Assembly, but it was still not a directly elected body.
Yes.
It definitely had learned men and women who had the interests of the country at heart, but what they intended in 1950 can't hold good for 2025.
Right.
And as Justice Khanna said in his that very judgment in Keshwananda Bharati, which
Yes.
tilted the balance, he said no generation has a monopoly of wisdom. Therefore, constitutional interpretation has to evolve with the times. So let's not worry about what the constitution makers thought.
The next question I would seek your comments is that do you think a time has come that a debate should take place on the accountability of the governors and also with regard to the discretion part of it? That how does one define discretion? Is it an elastic term? Uh, Incapable of any judicial scrutiny?
I was hoping, General, that you'd ask the third question, that should the office of the governor exist at all, which some people have asked.
That would be the next, yes.
So let me put
You
that
could take
question
that
also
first,
into your
yes.
mouth and answer all these together. Now, the governor is already accountable in one sense that he holds office at the pleasure of the president. So he's accountable to his political boss, definitely. Now,
Constitutional boss, yes.
yes, to his constitutional boss, who is really his political boss.
Okay,
But what the accountability which we are talking about is
yes.
constitutional accountability. This judgment does not negate constitutional accountability. Waters it down definitely a bit, waters it down from the Pardiwala doctrine definitely. Accountability continues to be there. And as to why, as far as discretion is concerned, if you have a cabinet form of government, you are still left with an element of discretion which has to be exercised in the British system by the Crown, in the Indian system by the President or the Governor. If you didn't have a governor, who was going to decide who would be invited to form the government in a state? In the case of a clear majority, obviously the leader of the party with the largest majority. But the scope for constitutional discretion comes in when there is no clear majority. Then you apply parliamentary conventions, long settled constitutional conventions. President R. Venkatraman used to issue communiques because there was more than one government which he was swearing in during his tenure. So similarly, a governor has to decide. Nobody else can decide who's to be invited. Secondly, in this quasi-federal form of government which we have, Article 356, if the government of a state cannot be carried on in accordance with the provisions of the Constitution, someone has to make a report. It may be subjective satisfaction, but on objective materials. Our constitutional system can't work unless you have a governor. And there are these constitutional silences which vest discretion in the governor. Those are unavoidable in the system of government which we have chosen. So therefore, governors, we have to live with them. They are here to stay.
Okay.
Of course, we can only hope that they act responsibly. We must also hope that chief ministers act responsibly. There has to be a sense of constitutional conviviality, mutuality. But these are truths which we have to utter and from time to time and remind ourselves. But in breach, what happens more is the breach of these. You have to remind yourself from time to time. It's like, as practicing lawyers, we are sparring with the bench every day. But on occasions like Law Day, on Independence Day, Republic Day, we'll all tell each other, bar and bench are two wheels of a great chariot. So we have to keep reminding ourselves of this ideal, even if we keep departing from the ideal every day.
You spoke about Pardiwala being good in part
Yes.
and not so in some other part. But overall, what happens to Pardiwala's order now, the judgment now?
Thank you for that question. I thought about it. Now, that judgment has implemented itself in the sense that after the declaration of deemed deemed assent, the laws in question were gazetted by the Tamil Nadu government the next day. So, as far as those particular bills are concerned, the Pardiwala judgment got implemented. But now the Pardiwala judgment is a dead letter for the reason that the Supreme Court has said timelines can't be laid down. Then, as far as the timeline for the president is concerned, which was mentioned in the Pardiwala judgment, Supreme Court has said that's obiter dicta. So, for the future, the Pardiwala judgment doesn't exist.
Okay.
I think
Right.
your question is capable of as simple an answer as that.
My next thing I would like to ask you is that what do you see the way ahead?
The way ahead, General, I thought I had already indicated a few minutes back.
Yes.
The way ahead is an encouragement to rogue governors, and the way ahead is lots of cases in the Supreme Court
So that is
filed by
what
states.
you see ahead, and that's what you are anticipating. Yes,
Yes.
I get it. And I have no more questions. Is there any other part which I may not have asked and strikes you and you'd like to speak on?
No, I think I've covered everything, but there's something which I wish to reiterate with a different emphasis.
Kindly go ahead.
Judges of the Supreme Court sometimes feel strongly about cases which come before them, and they want to lay down the law because of their sense of justice and because they can't see injustice happening. But even their judges also have to strategize. Even the best intentioned judges have to strategize like we lawyers have to strategize.
Yes.
And therefore, I am only re emphasizing the point that if Justice Pardiwala had thought ahead, it could have been a more authoritative pronouncement by the Supreme Court. A five-judge bench may not have necessarily given the same judgment which Justice Pardiwala gave. It could have been a majority judgment, but there were equal chances of the matter being decided one way or the other. What was the point ultimately of giving a judgment which didn't last for more than 4 months? This is something which our best judges need to think and reflect upon.
Thank you very much. I think you have brilliantly put across and traversed entire portion right from Justice Patiwala's judgment to the advisory opinion and also this self-inflicted injury as you sort of without using the word indicated. Thank you very much.
Thank you so much, General. Pleasure to be on your show.